All right, Tim Blankenship here with Divorce661 Daily Perspective, episode 18 for Thursday, October 26, 2023, I believe. Got a lot for you today. Have a lot of good info for you. Going to go over what we did today, clients we helped, and as well as some things I haven't talked about before. We're going to talk about how to bypass the LA County divorce classes. If you're in LA County, you know they have the classes you have to attend. We're going to talk about the health insurance open enrollment. That's an interesting topic for today. And I'm adding a new topic. It's until I have a better title, Tim's Tirade. And it's going to be at the end of the show where I go over the things that make me upset about, I don't know, maybe clients, maybe the paperwork, but mostly about the courts. That can be very frustrating. Okay, let's get into it. We're already at a minute. All right. So consultations today, had 6 consultations today from all over the map in California. We had Riverside County was represented, San Mateo, Santa Cruz, Yolo County, Monterey County, and LA County, always LA County, of course. And one person texted me from Monterey County just asking if we handle divorces in Monterey County. And obviously, yes, we do anywhere in California. And they just weren't ready for a consultation. So they were just reaching out and found us on the podcast. So thanks for watching if you're on YouTube, and thanks for listening if you're on our podcast where the audio version is coming from. All right, new cases today. We filed 3 new cases today. One in LA County. Of course, that was e-filed. And I already had that back this morning. I filed it at like 5 in the morning and I had it back at 8 right when the court opened, which is awesome. One in Sacramento County. Sacramento County does not have e-file on anything. We can't even e-file the initial petition. It's all old school, mail in your paperwork. Kind of annoying, but there's still some courts out there that are like that. And then one in San Luis Obispo, filed a new case there, and they are e-file on the initial documents. So we can get that electronic signatures on the petition. And they have also a procedural documentation, and then we can e-file that. But after that, everything is snail mail. All right, judgments that I prepared and where we prepared them, like what county. So today, Wednesdays, I get my bulk mail from people that are mailing in from all over California for their people that we worked with and finalized their settlement agreements, and they've signed all their paperwork, and we have to mail file, as I mentioned, because only LA County allows the judgment to be e-filed at this point. So 6 judgments came in the mail today, and they were from cases we finalized in Contra Costa County, Santa Clara County, Monterey County. Told you, the guy who texted me, we do Monterey County. Just finalizing that. And Orange County, Sacramento County, and Solano County. Been getting a lot of clients in Solano, it seems, lately. Always in Sacramento, always Orange County, always Santa Clara, Contra Costa, LA, etc. But anywhere you're at, we can help you. Okay, we had 3 cases, three judgments that we had submitted previously approved. Today they all came in. 2 were in LA. They're all LA. 2 were downtown LA. 1 was in Pasadena. I still consider that LA. So 3 approvals for our clients, and they are done. Most of these were because we handled these so quickly, and because we can e-file at the 5-week mark. They were their divorce is approved. We're here in October, but they're not officially divorced until March, I think was most of the dates on those that came in today. Today, as far as settlement agreements, I worked on 3 cases where we're drafting the settlement agreement. They got me their terms regarding child custody, child support, if that was applicable, property division, all that. And I got those finalized and out to them for review, and I'm sure we'll be finalizing those real quick. I want to talk about fee waivers. So that was the update, and now I'm talking about things that happened today that I want to comment on, so you can better understand the process. So I had a client that we filed today that was a fee waiver case. They've changed the fee waiver process. Before, you had to do the fee waiver and you had to qualify based on your income. Excuse me. And even if you were unemployed, you still had to show income. You had to show evidence of your unemployment. You had to show that receipt you get from, not receipt, but the I don't know what you'd call it, the evidence you get from unemployment that shows here's how much you're getting. We'd have to attach that to the request for the fee waiver, it wasn't just based on unemployment. That's now changed. I don't know when this went into effect. I should probably look at the date. It's been fairly recent. It was this year. Now unemployment, just by the mere fact that you're on unemployment and it's unverified, that we don't have to attach any evidence of your unemployment, it's an automatic fee waiver approval. So for those that you're unemployed, not to encourage you to file for divorce, but if you are on the fence or, the money is the issue, there's not going to be any court fees. And I commented probably a few weeks ago that I was just talking to my neighbor and her son works for the studios, and she said he's been out of work for basically 6 months. So that is awful. I guess the silver line is you can get your court fees waived if you're going through divorce. That didn't make sense. Okay. Number 2, Contra Costa. I was working with clients this week, wrapped up their settlement agreement, and they were going to they have to mail that in because it's another court that doesn't allow for the judgment to be e-filed. And I verified that today because they actually had said, and this is kind of a subtopic, they said, hey, Tim, when we look at the e-file services, the judgment does show on there, judgment and some of the procedural forms for the judgment package. And so I looked at it and I said, oh, you're right. It sure does. I said, well, I already had, because we have a lot of cases with Contra Costa. I said, well, let me e-file one now. I was getting ready to mail it. Let me see if I can e-file it. And it was rejected in about 4.5 minutes. And it said, we're not currently accepting e-file on the judgments. We just have the portal set up that way, but we're not accepting them yet. So that would be amazing if Contra Costa started allowing for e-filing of the judgments. Looking forward to that. In fact, I'm looking forward to all courts allowing that at some point. I told my wife a few weeks ago, I said, you know what? Handling the cases outside of LA County that don't have e-file, not because you're out of the county, just because there's not the e-file. I said, they take me twice as long to process for me and for the client, because whereas the LA County clients don't have to print anything off, that's all e-signed through my portal. It's all e-notarized through a service I use. Everyone outside the county, they have to, once it's prepped, they have to print documents, go to a regular notary, mail their stuff to me. And because we can't, even the counties that don't allow for e-notary don't even allow for electronic signatures. They have to be original wet signatures. So you have to print it, sign it, notarize it, mail it to you. I mean, and that's why I'm always talking about all the judgments we get in the mail. That's why that's happening. Because we can't, even if they accepted electronic or scanned signatures would be better, because then you can sign them, scan them to me, and then I can prep them, but that's not the case. But what I was going to talk about with Contra Costa is that when I was having this discussion with this client about the possibility of doing the e-file, which we now know we cannot, she said, oh, I'll ask, they were using the self-help center, emailing with them. She said, oh, I'll email self-help and see what they say, if they know anything, just trying to be helpful. And she got an autoresponder that basically said, due to how busy we are, we'll respond to your email in 3 weeks. 3 weeks, people, to get an email back from the court. All the counties are bad. I don't want to hate on Contra Costa. I do a little bit, but because they make things difficult. Anyways, just there's a way to get around. You do not have to use the self-help. You don't have to go to the court's classes. You use a service like mine, and we bypass all of that process. You don't have to talk to them. You don't have to go to court. You don't have to see a judge. We streamline the process, and we go straight to judgment, and you don't have to worry about any of the self-help type services, classes, or going to court. That's the service I offer, in case you didn't know. Okay, so we already talked about the judgments require original signatures. All right, note here, 2 cases this week where wife was going to keep the home 100%, including the equity, and be responsible for the mortgage. So today, did I say this week? So today I had 2 consultations, and in both cases, they wanted to know, we're concerned. I think the question was phrased this way. We're concerned the court will have something to say about me keeping 100% of the house. And it's a simple answer. The court does not interfere in your decision-making. The court doesn't know if you owe more on the house than it's worth. All we're saying is you're going to keep 100% of the house, and you're going to be responsible for the mortgage, and call it a day. So don't worry about it. The way we draft the settlement agreements, you tell us what you want. We put it together. The court's not going to interfere. Doesn't matter if you're keeping 100% of your home, 100% of your pensions, 100% of your kids, to some, for the most part. they're not going to interfere with that. They do care about the children. They don't care about your assets is the point I was trying to make there. Okay. Next subject. Okay. So this is just me messing with you. I have clients. We have a lot of clients, obviously. I've been doing this 11 years. We have clients that once we submit the judgment package to court, the ones where we have to mail in, they track, I think they're checking daily or at least weekly to look for updates with the court. So here's how it works. When we submit the judgment to court, it's all packaged up, hole punched, all stapled, and all the way it's supposed to be put together. We will give a track. We'll do USPS priority, so they get tracking, so they have confirmation that it arrives at the court. But after that, nothing. There's no updates. The court doesn't say, "Hey, we received it." You don't get a receipt. They don't call you. There's no indication. There's nothing on. Nothing gets on the case summary until they actually start reviewing it, which could be several months down the road. And then it's done in pieces, meaning the procedural documents, because the way I submit the judgment package is with everything. We do the initial filing, the petition, summons, and whatever else is involved in that county. And then I don't turn anything else in until we have the settlement agreement, all the procedural judgment forms, what I consider to be the entire judgment package in one shot. And once they get that and they open it, at some point prior to the judgment being reviewed, they will file those preliminary, disclosure forms and the proof of service, the notice of acknowledgement, the 141s, everything that's not considered the judgment or settlement agreement portion. And so they'll see that and they'll screenshot it, or they'll just email me through our portal and say, "Hey, Tim, this shows up today. What does this mean?" And honestly, all that means is they're starting to review your paperwork. That's it. It's not all I can tell you is, you ever heard the phrase or saying that whatever it is you're looking at, if you're watching it, it's going to take longer. Food takes longer to cook if you're staring at it. The coffee takes longer to drip out the pot if you're looking at it. I don't know why. I know you want your divorce to go through. I guess that's the real issue there. You want it to go through. Try and relax. Don't worry about it. The court time frame is going to take what it's going to take, and there's no updates that I can give you until I get it back from the court approved, and then I can send you your documents, and then you'll know you're done. Okay, the next question that came in today, my light went off. The next question someone had today was, how detailed does the child custody need to be? The answer is, it doesn't have to be. Child custody can be this simple: joint legal, joint physical, reasonable right of visitation to both parties. That's it. You can exercise that visitation all you want, custody in any way that you want. Did I not pay the power today? Lights keep going off. Want to make sure. I'll make sure you can see me. So yeah, it does not have to be in any way, shape, or form any type of. Bear with me. Does not have to be detailed. You don't have to list dates and times of when they're with and who has them in the car and all that. All you need is joint legal, joint physical, reasonable right of visitation. And I'd say 90% of our judgments or settlement agreements, that's all it says. So you don't have to make it complicated, people. If you're amicable, keep it amicable. All right. So I want to talk about this health insurance open enrollment. So I just Google searched this, so don't kill me if I'm wrong, but it said in California, the open enrollment is from November 1st to January 31st. I am not a life insurance. I'm not a health insurance agent, so I'm not going to be talking about any of that. If the open enrollment is wrong, I'm sorry, but that's what Google said. Blame Google. November 1st to January 31st. So this is why I'm bringing this up. Two ways this question's coming in. Tim, when can we take our spouse off? So from the person who has, let's say that my spouse is on my health insurance and our divorce just finalized, like we got it approved, like in one of those instances where I was saying it's approved now in October, but not officially divorced until March. So technically you're supposed to keep your spouse on your health insurance plan until then. But what if you guys agree that you want to remove the spouse so they can just get their own insurance now, open enrollment? That is totally fine. So the question came in two ways. So last week, a client who we had finalized their divorce, but they still had that time before they're actually single. he said, Tim, do I have to remain on her health insurance, or can I go and get my own now during open enrollment? Absolutely. You can do that. Then the question that came in today was on the opposite side. If we start our divorce, and even though it's not finished, can I remove him from my health insurance policy because of the open enrollment? So it's not because of the open enrollment you can, it's do you guys agree to do that is what matters. The summons says, and this is what people are referring to and why they ask the question, it says, don't change beneficiaries, don't remove off health insurance, don't move off of auto insurance, all these things need to stay intact until the divorce is final and the 6 months have passed. That is so you don't harm each other, like do things in a negative way. But if you agree to do these things, then you're welcome to do them. You don't have to, the only person who's going to complain to the court is both of you. The court's not going to say, hey, we got notification that you removed him off health insurance or vice versa, whatever the case might be. I handle purely amicable, 100% cooperative clients. Okay, I know it's divorce, so it's not, always exactly a beautiful thing, but don't worry about what the summons says if you guys are making agreements. We've had people say, Tim, we don't want to, we're dividing every single little asset or debt because that's what the court says we have to do. Or I want to move out, but it says we can't change it. I mean, people are really reading it to the letter of law. The simple answer is, if you want to make changes to beneficiaries, automobile insurance, health insurance, and you guys agree to do that, you can do it. All right. So here is the last section. And let me know if you have a better word for it. I'm going to call it Tim's tirade. I'm looking for something that rhymes, but something that says that I want you to know that I'm upset about something. So a week ago, last week, probably, I was talking about how sometimes clients take advantage of my service and my free consultations and how I say, shame on you for doing that. And it happened again today. And they knew it, and I called them on it immediately. They said, I have a couple of questions. I'm trying to do my own divorce, but I want to get a couple questions. And I said, oh, well, let me talk about the fact that you're going to be doing your divorce yourself. She goes, oh, we'll get into that after you answer my questions. And I said, I'm sorry to tell you, if you have absolutely no intention of hiring me, you really shouldn't be calling me, because the purpose of this consultation is to find out from you what you guys have going on, see if you're amicable, cooperative, and all that. And then for you to learn about my service and make sure we're a good fit, not to call and get free legal advice, which first of all, I can't give you. They're asking highly technical questions about quadros and taxation and all this. And I just had to say, look, you're obviously looking for free resources. You already told me you've been calling around for other things. I can't help you. That's not what I do. I don't do piecemeal parts. She's like, well, we're gonna do our paperwork and then maybe I'll call you if we get stuck. No, I don't do that. You either decide to hire me or you don't. I do take on cases where your judgment's been rejected or you get stuck somewhere in the process, but that's not what this person was doing. They were going to try and call all different people to get help for all this. She was asking me, how do I get free resources for this? Or I want to get a disto master. How do I get that? I'm like, you got to pay someone to do it or hire someone. It's part of my process, but I'm not just going to do it for you for free. So a little frustrated on that. And here's where I don't understand why people do this. She had 5 401ks. You mentioned IRAs, spousal support. They had kids. They had a home. And you're going to try and do your own divorce. She had questions about how do you write it in the settlement agreement to make sure that it can be quadro. Can we use a flat amount, or does it have to be community property? It's like it's not a complicated case. It's the type of cases we take on all the time. As long as you guys agree the terms, we'll package it up that way. But you're going to try and do your own divorce with all that involved. It's not a simple, no asset, no debt, no kid, have been married for 3 days divorce. I don't understand why you guys do that. These people are going to be at this for well over a year, because not only do they have the challenges of doing their own paperwork, missing check boxes, filing things wrong, errors, judgment rejections, but they're going to mess up their settlement agreement entirely, which is going to mess up their quadros, which is going to delay the transfer of assets. Let me know if you like Tim's tirade. Let me know if you have a better name for it. I hope you enjoyed episode 18 for this Thursday, October 26, 2023. Divorce 661 Daily Perspective, and we'll talk to you mañana.